today as well, and where we stand in terms of the parliament and the judiciary. It's important, of course, to see how this case is proceeding and who's taking a look at it. Earlier also there was discussion whether or not the CJP-led bench is appropriate in terms of hearing this particular case, which of course talks about powers that is going to then impact the CJP as well. I'd like to take your opinion on that with regards to the bench that is hearing this particular case. Does that not impact the decision making of this particular case, and whether or not there is any legal line that is being crossed at the moment? Shabir Saab, you'll have to unmute yourself. We are unable to hear you.
Thank you twice. I thank you first for taking me on your show, and second time for enabling me to unmute myself.
You're welcome.
Sana, the legal question before the Supreme Court is that the Honorable Supreme Court is examining the vires of a bill. So there are three things. Even if we not examine at the moment as to whether or not the law is constitutional or unconstitutional, the first point is whether any court, even if it is Supreme Court or the High Court, can examine the constitutionality of a bill. Do you hear me?
Absolutely,
So
yes. Yes.
All right. So the first legal question is, can a court examine the vires of a bill? The answer is, it's an open and shut case. No, the court cannot examine the vires of a bill because, first of all, it is the prerogative of the executive, which is the cabinet in this case, to propose a bill, and the parliament then has to consider it. And then after that, the court has to take into account the vires of any law once the law is enacted. So there I would, with respect, submit that insofar as these proceedings are concerned, I think it will have not good consequences for future precedent as well. Now, examining the second aspect of the case, which is whether or not the court can pass an interim order suspending the operation of a law. So let us assume that this was already an act of the parliament and it was not a bill. Even in that case, can the court suspend the operation of a law is a legal question. So far, we have three judgments. One which is expressly recognized in the order itself, which is Dr. Mubashir Hasan case. In other words, NRO की case से 17-member bench judgment है. उससे पहले चौधरी एतजाज Ehsan's judgment is there, and before that, Dr. Liaquat Jatoi's case is there. In all the three cases, the Supreme Court has settled a principle of law that you cannot suspend. You cannot suspend operation of any law. You cannot pass any interim order. So there also, this interim order, which has suspended the operation of a bill, not even a law, on that account also, with respect, I humbly disagree that such power ought not have been exercised, because this is new jurisprudence. The third aspect of the matter is whether or not the Honorable Chief Justice, whose very powers have been called into question through the proposed legislation, he should have been part of the bench or not. Now the answer is twofold. Legally speaking, it is still his prerogative to decide whether he would be part of the bench or not. Morally speaking, or speaking as to whether or not it is appropriate, I think it would have been more appropriate if he would have formed a bench in which he was not part of that bench. The fourth aspect of the matter, which although I'm not called upon to comment on, but I think it is extremely important to shed light on, is whether or not this law in itself, if it was converted into as an act of the parliament, is constitutional or not. In my humble opinion, in my study of the Constitution, this aspect of the law, which seems to amend Article 184 of the Constitution, which in itself is the original jurisdiction of the Supreme Court. Now, if the original jurisdiction of the Supreme Court is to be amended, it must be amended through a constitutional amendment. It cannot be amended through an ordinary law. So there, hypothetically speaking, if everything was appropriately in place, and even if 17-member bench of the Supreme Court sits to review this law, I maintain my opinion that this law would be struck down.
Right, absolutely. And thank you, Barrister Saab, for outlining in such detail what is going on. But I want to then understand that if all of these aspects exist, it seems that there are lots of question marks, orders of May 14th being the deadline. I want to understand what is going to be made of that particular date with regards to the Supreme Court's directions, because it seems as of now, we know that the parliamentarians, of course, have refused it. There have been resolutions passed. The Prime Minister has refused it. There is, of course, also the issue of the funding, which has also been rejected, and everybody in the ruling alliance is claiming that the elections, of course, are not possible on the May 14th, and they seem unlikely as well. So what is then the current standing of the Supreme Court's orders of May 14th?
Sana, before I answer, allow me to, with respect, disagree with some of the comments which were made earlier in your program by your honorable guests. And with respect, may I state, it is one thing to disagree with the judgment and putting forward your legal analysis, but it is completely another to attack or make personal attacks on the Honorable Chief Justice or any judge. I mean, constitutionally, we are obliged, we are obligated to respect each and every judge of the Honorable High Court or the Supreme Court or even the lower courts for that matter. It is straightforward. It is a contempt of court. It is contemptuous. And if we were in previous days, I would not be in a position to even defend such remarks. I mean, that is so much for that, and forgive me for being honest, but this is my legal opinion also. Sorry.
To respond to, yes.
Because you were commenting to what I was saying earlier, sir, regarding Constitution, of course, Constitution has somehow become the come and go room. It comes whenever it is required by certain powerful or privileged people. It is not there when it is, it serves the common man on the street like me. But regarding what you are just saying, with due respect, I have clearly stated on this program that I am open to the idea of being summoned in contempt of court if I am saying something wrong. Just prove it, call me, punish me, I am okay with that. But sir, don't become the moral police. Please do go ahead and comment on what was being asked, sir.
With respect, I didn't get the opportunity to hear your comments, but if what I make out of it is that fair enough, everybody has freedom of expression. But commenting on the constitutional respect which the Constitution mandates for the Supreme Court and the judges, we must all be wary of that. We must all show respect, because you see, sir, it's not about today. It is about hundreds and hundreds of years to come. You and I might not be here. Pakistan is like a ship. The state is always going to stay there. The Constitution is always going to stay there. So let us not think about today or tomorrow or this government. Let's think about the rule of law. Now, imagine tomorrow also, the rule of law. What kind of rule of law would we want to live in? We would want to live in a rule of law where there is a court, there is an independent court.
Barrister Saab, you are preaching to the choir. I think that this is for the first time that you have watched this program, or at least my submission. Otherwise, you would have known that in principle, I agree with that. But my humble submission is that contempt, is not actually something that is done willingly. It can happen accidentally also, and when it comes from the court itself, then do we not even have the right to actually point it out that there is a contradiction that is going on? Right now it seems that the way the Honorable Court has conducted itself over past 4 months, and yet then I have to actually behave as if there is a religion, and I have to actually, if God forbid I am going to comment on something, it becomes blasphemy. I'm sorry, I'm not going to actually concede that. But I do agree, in the long run we need structure, we need respect for institutions, but that also cut both ways. When the Supreme Court asks the Speaker of National Assembly to provide the minutes of the proceedings, then I think that it is no more about respect or contempt, it is about power politics which is going on.
All right, Barrister Sahab, you may respond to that and then please quickly also answer my question. Yes, carry on.
Maybe I'm not expressing clearly. You are old enough. You cannot be schooled at this age. I say that maybe you would not have understood me correctly. But having said that, I move on to another aspect. Sana, through your program, may I share? I've written an article on exactly commenting on this scenario, which is that the Supreme Court is going to save the Supreme Court. That is the only last resort. It was published in the news last week. The worrying aspect is the state of the judiciary at this point in time. You see, the common man, rightly or wrongly, thinks that there are two Supreme Courts. One which is pro CJP and the other which is anti CJP.
Right. Right, absolutely, and I understand your point, but Barrister Sahab, I quickly also have to go to Mr. Adil before we conclude the show. And Adil Sahab, I'll take the question regarding the Supreme Court's May 14th order to you. Where does it stand at the moment and how will it stand